My special thanks to the former President of Greece, Professor Pavlopoulos, and indeed all the international speakers who will be participating in panels today. And please forgive me my pronunciation of your names. From Greece, Professor Pazarkis, Marias, and Perakis, the former Greek ambassador to Poland, Christianopoulos, Mayor Papadopoulos and Stathas, and Attorney-at-Law Ms. Christina Stamuli. From Poland, Professor Bainczyk and Dr. Sobolewski. From Italy, Attorney-at-Law Mr. Biole. And from Serbia, Dr. Dragan Novorus. Although he couldn't join us today, I would also mention Professor Mereshko Alexander, Ukrainian MP and Chairman of the Foreign Affairs Committee, who was invited to speak. Without doubt, our panelists today are experts in their fields. So, why we are here today? Our main aim today is to develop the conversation about post-conflict justice, to discuss how we can open legal path to victims of conflict path which today are closed. Legally, over decades, numerous court cases have been heard which have faced the same legal barriers, ultimately preventing victims from seeking redress. Politically, the issue is said to be resolved, and this path remains closed. Historically, temporary approaches have tried to change the undisputed narrative and seemingly turn aggressors into victims. This conference will attempt to tackle all of this issue and help to resolve the historical problems that remain unresolved after the Second World War. This conference is also being held today to help to educate listeners and viewers so they can be better informed when facing contemporary narratives that aim to minimize the extent of war crimes, introduce artificial separation to create new aggressors, or identify victims where they are known. This is important. If the contemporary narratives are not fought, they will become accepted. These revisionist narratives will then shape future legal decision and policy. The result of not challenging those revisionist narratives will have a clear determinantal effect on future victims of legal conflicts. If we cannot identify exactly who the aggressors and the victims of a conflict are, or suggest a mechanism through which victims can seek legal redress, we will fail not only past but future victims of legal conflicts. This conference also aims to highlight the fact that international efforts are required to help countries truthfully reconcile after conflict. Reconciliation comes through discussion and openness. Victims are willing to talk to aggressors to provide evidence of harm and to seek resolution. Aggressors putting up legal and political wars and refusing to discuss historical problems cannot be the solution. These are problems that affected people today, leave people with a burning sense of injustice and will not be ignored. Ignorance is no defense in law, and this is especially relevant given the amount of evidence that exists today and survive conflict, despite the best attempts of aggressors to destroy the evidence. Poland's war report published on the 1st September 2022 is an example of what victims' countries can do to document their material and human losses using internationally accepted methods. The findings of Poland's war report were completed by experts across numerous fields. The findings include figures such as 5.2 million Poles were killed. After the war, Poland's population decreased by 11.4 million people. 2.1 million Polish citizens were used as a slave labor. 590,000 Poles were permanently injured after the war. Almost 200,000 Polish children were stolen. The total amount of the reparation for human and material loss owed to Poland is 1,352,483 million euro. These were subject to peer review and then finally published. To date, the findings, which are conservative in nature, remain uncontested. The data is undisputed. The harm and losses are incontestable. The evidence was documented, analyzed, and calculated in terms of financial liability. Based on existing evidence and accepted international models, we must internationally cooperate in different fields, in law, in politics, in history, in academia. We must develop watertight legal approaches, develop policies to overcome political interior, and to disprove historical revisionist narratives. International cooperation is important for other reasons. Countries working individually have failed to find justice for victims of conflict. Therefore, we must work together to seek justice. That is why this conference must be held. The issue that we will discuss today needs to be heard, analyzed, and developed. I hope that this conference will be the first of many such conferences. Today's conference will specifically focus on a legal problem that seems to affect the victims of the past, the present, and the future. A problem that is so well known, but a legal problem that law has not sufficiently recognized or developed a legal solution for. This is particularly problematic if we refer to reconciliation. The legal problem allows both sides, the victims and aggressors, to both claim they are legally correct. Inevitably, this stopped the process of legal redress and lengthened the process of reconciliation. The legal problem is a victim's lack of access to post-conflict justice. Simply put, a victim harmed by illegal war started by a foreign aggressor cannot seek legal redress from that aggressor. No legal path is open for the victims to receive compensation. This is troublesome, as international law does exist to protect the victims, but that law is made ineffective because of other superseding international doctrine. The Hague in 1907 passed regulation concerning the law and custom of war on land. Section 3 states that a belligerent party is liable. The message is clear. If a state starts illegal war, commits war crimes or crimes against humanity, it is irrelevant when these crimes are committed. It is this war that directly affected victims, and these victims should be able to rely on human rights legislation, such as Article 6 of Convention for the Protection of Human Rights and Fundamental Freedoms. Article 6 allows both victims and aggressors to have a fair and public hearing. However, in practice, we can see differences. The numbering trials showed how the international legal system allowed Second World War criminals to be fairly tried for their awful crimes in a court of law. However, the same international legal system does not provide a way in which victims can raise claims to seek redress. The reasonable men might ask themselves, if an aggressor has started an illegal war, has committed war crimes, and can be fairly tried in a court of law, why can't a Second World War victims who suffered harm or loss not bring in their case to the court? However, the answer is simple. State immunity prevents an individual from raising a claim. You can see the next paradox when we compare access to legal redress under domestic law and international law. Domestically, the law in our constitutions and statutes protects and punishes the citizens who are subject to it. Simply speaking, if you break a law, you are punished. If there is a victim of the act who is harmed or suffer loss, they can seek redress. In Poland, as in other civilized countries, if a criminal commits a crime, murder, rape, assault, arson, among others, if we change just one element, we get a different outcome. If a state act commits these crimes in another state while engaging in an illegal war, suddenly the victim has no right or legal redress. Once again, a reasonable person might ask themselves the question, why? However, the answer is the same. State immunity again stops the victims from raising claim. Another paradox is shown if we discuss asymmetry of fairness. This cannot also be seen if we compare domestic and international law. Domestically, would a court allow an aggressor to determine who they should compensate and how much? As a part to many of the agreements, but they sign allocating individuals' compensation, determine which countries and which individuals should be compensated. The German state had before. Germany played a role in determining how much individuals from certain member states would be compensated. The Germans were also party to agreements for Holocaust survivors, Jewish organization, and the State of Israel. However, Poland, the European country that suffered the greatest human and material losses of all European countries in relation to the total eligible population and national wealth, was party to no agreements with the German state. Can Polish victims and victims from other states who were not compensated or inadequately compensated raise claims against Germany? No. Why? Once again, state immunity prevents them from doing so. We need to address through convenient, blanket defense of state immunity. This defense overrules all other international doctrine. We need international legal solution to this paradox. As it stands, there is a clear imbalance that favors the aggressor over the victim. Human rights legislation is thoughtless when legally assessing the acts of a state run by a war criminal that is committing horrific war crimes. State immunity simply allows a state to act with impunity. I wonder if the current discutable war in Ukraine will change people's minds. Indeed, in the Reykjavik Declaration might be a sign that it signals a change in approach. The Reykjavik Declaration aims to establish a future international comprehensive compensation mechanism. This mechanism will difficulties of codification, an early attempt to codify, and many are in the room with us today. With the clear development of case law and doctrine, with the development of international law strengthening the protection offered to victims, and with the current war in Ukraine providing a pertinent background for development, I would urge you, the massacre case in Greece, the 2060 case in Poland, the 2000 suffered by victims, including civilian massacres, the use of slave labor, stolen children, and all manner of individual harm and loss. Case law drives statutory change. This, along with constitutional provisions, allow the sovereign protection of victims and allows victims to raise claims against an aggressor. The grant is being prepared for the protection of human rights to supersede the blanket convention, convenient defense provided by state immunity in case where victims suffered as a result of illegal wars started by war criminals. A legal test based on evidence and fact should be discussed and developed that would allow a court test to be passed. This test would allow compensation to be paid for victims. The idea is not new. In 2013, the UK paid compensation to Kenya Mau Mau torture victims. Although the case was settled out of court, the UK government said that the evidence provided would have passed a court test. Judges and lawyers also can play an important role to play in changing the legal approach to make law more equal and fairer. The law of equity dating back to Roman times is an affirmative defense that is applicable when the law is not flexible enough to deliver a fair resolution to a case. The affirmative defense of equity clearly has a role to play in allowing Second World War victims to both hear their cases in the court and receive adequate redress. Judges and lawyers should be brave in examining all options where a legal solution lead to clear thinking through the sharing of ideas and discussion. Collectively, we may begin to formulate solutions and legal tests to introduce a reasonable exception to the non-discriminatory protection provided by state immunity. By sharing case studies, by discussing avenues to seek redress, by analyzing how international organizations may help individuals or lead to the recognition of the individual claims, today we are stimulating and encouraging debate. We are taking the first step along the road of bringing justice to victims of illegal wars started by war criminals in the past, the present, and in the future. With that being said, I look forward to the first panel debate on the legal path aspect of the redress in public and private international law. Thank you.